Across America, a battle rages between the rule of law and the defiance of sanctuary cities. These havens for illegal immigrants have ignited a firestorm of constitutional debate. Can states and cities ignore federal immigration law? The answer is no. Sanctuary cities undermine the Constitution and the rule of law. We must stand firm and end these rogue policies. The Constitution is crystal clear. Immigration is an exclusive federal power. Article 1, Secretary Walidi Ndiririvo, Section 8 unequivocally grants Congress the authority to establish a uniform rule of naturalization. This means that the power to determine who enters our country, under what conditions, and with what legal status rests solely with the federal government, not with individual states or cities. The Founding Fathers, in their wisdom, understood the importance of a unified immigration policy. And they recognized that a mosaic of conflicting state laws would lead to chaos and undermine the nation's security. By placing immigration power squarely in the hands of the federal government, they ensured a consistent and coherent approach to this critical issue. Sanctuary cities, in their defiance, are attempting to usurp this constitutional authority. They are essentially arguing that they have the right to pick and choose which federal laws they will enforce and which ones they will ignore. This is a dangerous and slippery slope, one that threatens the very fabric of our constitutional republic. The Constitution is not a buffet where states and cities can simply select the provisions they like and disregard those they find inconvenient. It is the supreme law of the land, and its mandates are not open to negotiation or nullification by rogue jurisdictions. Proponents of sanctuary cities often attempt to justify their defiance by invoking the 10th Amendment. They argue that immigration enforcement falls under the purview of state police powers reserved to the states by the 10th Amendment. This argument, however, is fundamentally flawed and reflects a misreading of both the Constitution and the history of federalism. The 10th Amendment states that powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. While it is true that the 10th Amendment safeguards the principle of federalism, it does not grant states unlimited power to disregard federal law. The Constitution's Supremacy Clause, enshrined in Article 6, clearly establishes that federal law is the supreme law of the land, superseding any conflicting state or local laws. When a state law clashes with a federal law, as is the case with sanctuary cities, federal law reigns supreme. Furthermore, the 10th Amendment cannot be used to justify actions that directly contradict an enumerated power of the federal government. As we have established, immigration is explicitly granted to Congress in Article 1, Section 8, preempting any state or local attempts to regulate it. The President of the United States takes an oath to faithfully execute the office of President of the United States and to the best of my ability preserve, protect, and defend the Constitution of the United States. This solemn oath carries with it a profound responsibility to enforce the laws of the nation, including those relating to immigration. When the executive branch, whether through action or inaction, allows sanctuary cities to flourish, it is failing in its constitutional duty to enforce the law. By turning a blind eye to these defiant jurisdictions, the president undermines the rule of law and sends a dangerous message that federal laws can be ignored with impunity. The president has a wide array of tools at his disposal to compel compliance with federal immigration law. He can withhold federal funding from sanctuary cities, direct the Department of Justice to bring legal action against them, or even deploy federal law enforcement agencies to assist with immigration enforcement. Failing to use these tools is not an option. It is a dereliction of duty, a betrayal of the oath of office, and a threat to the very fabric of our republic. Section 5. Echoes of disobedience, the nullification crisis in sanctuary cities. The audacity of sanctuary cities is not without precedent in American history. Their defiance harkens back to the nullification crisis of 1832 and 33. South Carolina's attempt to nullify federal tariff laws struck at the heart of the Union. President Andrew Jackson responded with unwavering resolve, mobilizing the military. Section 6. A nation divided. South Carolina's tariff defiance. South Carolina, emboldened by the support of other southern states, refused to back down from its nullification stance. The nation stood on the brink of civil war, the specter of disunion looming large. The crisis reached its peak when South Carolina declared the tariffs null and void and threatened to secede from the Union if the federal government attempted to enforce them. The situation was dire, a testament to the dangers of unchecked state defiance. The very foundations of the republic were shaken as the nation grappled with the question of whether states could simply disregard federal laws they deemed unfavorable. In the face of South Carolina's rebellion, President Jackson stood firm. He issued a powerful proclamation condemning nullification as unauthorized by its spirit, incompatible with its letter, inconsistent with its structure, and destructive of its great objects. Jackson's unwavering commitment to preserving the Union, coupled with his willingness to use force if necessary, ultimately forced South Carolina to back down. The crisis was averted, but not without leaving a lasting legacy on American history. Section 7. From schoolhouse doors to borderlines, desegregation and sanctuary parallels. The echoes of the nullification crisis resonate far beyond the tariff debates of the 19th century. We see its legacy in other instances of state defiance, most notably in the resistance to desegregation following the landmark Supreme Court decision in 1954. The decision declared state-sponsored segregation in public schools unconstitutional, a monumental victory for the civil rights movement. However, many southern states clinging to Jim Crow laws and determined to maintain segregation met the decision with fierce opposition. Governors, state legislatures, and local school boards employed a variety of tactics to obstruct the implementation of. They passed laws nullifying the Supreme Court's decision, denied funding to integrated schools, and even resorted to violence and intimidation to prevent black students from attending white schools. The most infamous example of this resistance occurred in Little Rock, Arkansas in 1957. Governor Orville Faubus defied a federal court order to integrate Little Rock Central High School, calling in the Arkansas National Guard to prevent 9 black students, known as the Little Rock Nine, from entering the school. Section 8. A human cost. The unseen consequences of sanctuary policies. The parallels between sanctuary cities and historical instances of state defiance are undeniable. They all represent a dangerous disregard for the rule of law and the principle of federal supremacy. Just as the nullification crisis threatened to tear the nation apart, so too do sanctuary cities undermine the very fabric of our republic. Beyond the constitutional implications, sanctuary policies have real-world consequences, often with a human cost. When cities and states refuse to cooperate with federal immigration authorities, they create havens for criminal aliens, putting their own citizens at risk. We we've seen tragic cases where individuals released from custody due to sanctuary policies have gone on to commit heinous crimes, including murder, rape, and assault. These victims, often forgotten in the heated rhetoric surrounding immigration, deserve justice. Their stories serve as a stark reminder of the human cost of sanctuary policies. Moreover, sanctuary cities create a magnet effect, incentivizing illegal immigration and further straining our already overburdened immigration system. This influx of undocumented immigrants puts a strain on social services, schools, and healthcare systems, particularly in border communities. Section 9. Conclusion. Upholding the rule of law, rejecting sanctuary cities. In conclusion, the constitutional case against sanctuary cities is ironclad. Their defiance of federal immigration law is a blatant violation of the Constitution, undermining the rule of law and jeopardizing the safety and security of all Americans. The Founding Fathers, in their wisdom, entrusted the power to regulate immigration to the federal government, recognizing the need for a uniform and coherent approach to this critical issue. Sanctuary cities, in their arrogance, have chosen to disregard this constitutional mandate, placing their own misguided ideology above the law of the land. We cannot allow this defiance to stand. We must demand that our elected officials at all levels of government uphold their oath to defend the Constitution and enforce the laws of the nation. The rule of law is the bedrock of our republic, and we must never allow it to be eroded by the whims of rogue jurisdictions. The time for complacency is over. The time for action is now. We must stand united in our commitment to the Constitution and demand an end to these dangerous and unconstitutional sanctuary policies. Only then can we restore the rule of law and ensure a safe and secure future for all Americans.